Hi everyone. I don't normally talk about personal injury law or criminal law issues. Today I want to talk about an interesting constitutional law issue that's coming up a lot in response to the stay-at-home orders issued by many states' governors because of the coronavirus pandemic. A lot of protesters have come out saying that it's an unconstitutional overreach, an act by these state governments that is infringing on their federal constitutional right to freedom of assembly. So in order to analyze this, I just want to give a little bit of a background about the source of power that the governors are using to issue these orders. Under the federal constitution, all powers not expressly delegated to the federal government are reserved for the states and to the people. That is generally held to include the state's police powers. The states have the right to police within their own borders and to make their own laws for the protection of their citizens. So the way this works between this duality between the state and the federal law is that a state law is generally valid unless it infringes on rights held by the federal constitution. So the protesters are basically, for the most part, and I'm not getting into any particular protester's argument, but I think the general idea is that these laws infringe on the First Amendment right to freedom of assembly. But the way that I think that this has to be looked at by the courts is the same as with any unconstitutional law or law that's alleged to be unconstitutional, in which courts apply a strict scrutiny analysis. Strict scrutiny is the name of the test that courts employ when analyzing whether a state's law, or in this case an executive action, is an unconstitutional infringement on a fundamental right held by the people. Most of the rights most of the amendments contained in the Bill of Rights constitute what are called fundamental rights. Now, of course, every fundamental right has its limits. The Second Amendment isn't unlimited. There's plenty of limitations on that. And the First Amendment is also not unlimited. Freedom of speech is, of course, a fundamental right and has long been recognized as a cornerstone of the democracy. However, it is not unlimited. You can't go into a crowded movie theater and scream fire. So there's always limitations. So when government action is curtailing one of those fundamental rights, here the right to freedom of assembly, to be free in your movements, to go out and to associate with who you wish, or in groups of more than 10 people, I suppose, and as the case may be, the government needs to show that their restriction is narrowly tailored in order to achieve a compelling government interest. That's the test that courts will apply. So to analyze that in the current situation, we have the first question is whether this is a compelling government interest. I think the answer is that it certainly is. Public health has long been recognized as protecting public health has long been recognized as one of the key reasons that people have governments. That's why we give the government these powers. The powers are the people's, and we confer them to the government in order to advance the general welfare of the people, the safety, and in this case, the health. There have been challenges in the past. There's the old Supreme Court case, Jacobson versus Massachusetts, challenged a law over compulsory vaccinations during a smallpox pandemic, and that was held to be a valid exercise of the state's police power during a time of crisis, much as is the case now. So I think based on those precedents, you have a pretty good basis for establishing that these government actions are in fact a lawful exercise of the state's police power toward a compelling government interest. The other question is now, are they crafted in the least restrictive means possible? And I think the answer to that is probably yes. These seem to be reasonably well reasoned measures that are designed to limit the spread of what is a very deadly disease by curtailing the amount of people who can congregate in public, and also by limiting which businesses may and may not operate. So as long as they're for a limited duration, which they are, indefinite but limited, it's not claimed that this is going to be a permanent curtailment of these rights. They seem to be pretty narrowly tailored and are basically geared towards the only proven method to limiting the spread of this disease is through social distancing, as there is no cure, there is no vaccine. Treatments are unproven at this point. The only known way to really curtail the spread of it is through social distancing. So based on it being a compelling government interest and the least restrictive means to achieve that compelling government interest, in my opinion, it seems unlikely that any court would find that these are unconstitutional orders by state government. But I expect the issue to be litigated in the future, and I guess we will see how it turns out.